Our second panelist today is David Fontana. Let me just give you just a brief biography of Professor Fontana before I turn the program over to him, where he will be talking about the psychological complications of dissenting by deciding. After receiving his JD from Yale University in 2005, Professor Fontana clerked for the Honorable Dorothy Nelson of the United States Court of Appeals for the Ninth Circuit. He joined the faculty at George Washington University Law School in 2006. He teaches there constitutional law, comparative constitutional law, comparative law, criminal procedure, and criminal law, some of my favorite classes as well.
Some are mine too.
Not all. While teaching at GW Law School, Professor Fontana also earned a doctoral degree in socio-legal studies at Oxford University. Professor Fontana's scholarship appears in numerous law review articles, including the Yale Law Journal, Virginia Law Review, and Texas Law Review. Please welcome Professor Fontana.
So thank you for that introduction, and thank you to everybody in the Tulsa Law School community for making it a wonderful day so far. As I said yesterday, I have a real penchant for organization, so the precision of the organization, everything down to the minute, is something I really appreciate. So thank you for that. So I want to make three kind of general points before I turn to substantive points. And so we're here today to honor the work of Professor Gerken. And I think the work of any law professor is not just about their scholarly or other writing. I think it's also partly about their contributions to the larger law school community, and even more so, their contributions to the law school where they teach. So I want to make 3 points about that. So when I was in college, I thought I wanted to be an academic. I wasn't sure in what. My parents were both academics, so I kind of knew what a good job it was. No comment. And I took a Myers-Briggs test, and the Myers-Briggs test showed I was an extreme extrovert. And so suggested professions included things like salesman, or game show host. That really, I was very kind of, upset about that, because neither was something that I planned to do. Neither did I need to take the LSAT for. So I had something of a crisis. Well, how can I be an academic and still want to interact with people? And I remember my first year of law school, I read a book by Owen Fiss, and the inscription of the book says, "Scholarship is not such a lonely enterprise, and from that comes much of its joy." And that quote really stuck with me. And so I think what Professor Gerken has been really great at, and you see this just already in the first 2 panels, and this panel, and just everybody here, is creating kind of a scholarly community. And I think that's part of what makes being a professor of any sort fun. It's partly the time sitting in your office writing, but it's just as much, if not more, the time interacting with others. 2 other things about service to her particular institution. So I graduated from Yale Law School, which I think had more of an impact on me than where I went to college or graduate school, intellectually and otherwise. And I graduated, I think, the year before Professor Gerken came. And there are really, I think, 2 kind of major things that Professor Gerken, or at least who added to the community, that I think were really desperately needed. And in fact, I graduated close enough to when she arrived that probably most of my friends had a class with her or were at law school at the time that she was teaching there. So the first is, I think, kind of a complete intellectual ecumenicalism, a real openness to different ideas. You see that in the very rare ideological diversity of the panels today. If you ever want to see how ideologically closed-minded law professors can be, look at who they thank in the start footnotes of their articles, right? It's usually overwhelmingly people with whom they ideologically agree. And I think the composition of the panel, the work cited in her scholarship, is really a testament and something that was, I think, really much needed at Yale at the time to kind of ideological openness. But I think even more important than that was a kind of status openness, right? So when I got the job at GW, I went up to Yale to visit with some of my references, and one of them said to me, "The best thing about going to Yale Law School and not getting a job at Yale Law School is you can use all the great ideas in this building at the other schools and nobody will know." And I think one of the great insights of Professor Gerken's work is that you can really have a dialogue between people in the building, but also among people in different law schools, and that the fellowship really comes from engaging people more broadly, not just the people down the hall, but the people writing in the larger law school community. And the other point, and I actually think this is perhaps the most lasting contribution of one's career, and I think perhaps I'm more sensitive to this because I have a female academic mother and now a female academic wife. Yale Law School had a real dearth of people who were both mentoring female law students as research assistants, then promoting them for clerkships and teaching positions, and perhaps most importantly, being nice to them. And I think having that kind of mentorship pipeline, what sociologists might call kind of sponsored mobility, has really been very important already, and who I see as kind of my new colleagues, both in the faculty at GW and other schools. And I think, decades from now, when we're looking back, we'll be able to see not just the influence of the articles, but also the influence of the other people who she worked with and what they went on to write. So I think these are all kind of really crucial things about being an academic that go beyond just the writing. So let me turn to the writing. So I am not an election law person. So I'll talk kind of constitutional law, comparative constitutional law, social science, some kind of combination of them. And my kind of response is to the dissenting by deciding line of work. So first I want to kind of send out how this relies on not just federalism all the way down, but particularly what's concerning about the three types that she's responding to is distinctive features of American federalism all the way down that make these kind of conflicts even more acute. And then I want to talk about how her framework kind of proposes to mitigate this, not eliminate it, but as she says, kind of adds to our toolkit rather than eliminating or supplanting others. And then talk a little bit about how the kind of organizational apparatus that's creating by dissenting by deciding can in some ways stifle some of the instrumental goals that she's trying to achieve, talking a lot about kind of political and organizational psychology and how certain types of distributions of power in different institutions create more equality, more creativity, and so on. So the first point, kind of, this is American federalism all the way down. So part of the story, I think, of these articles is not just sovereign servant cooperative federalism, but it's the David Shapiro, federalism as dialogue, and it's really the absence of dialogue. So it's federalism as sovereign servant, but kind of isolated, non-interactive, non-dialogic sovereign, non-dialogic servant, even non-dialogic cooperative federalism. And these are all kind of, I think, important additions. You could be a dialogic sovereign, a dialogic servant, and more obviously so a dialogic cooperative federalist. So let me give you some kind of comparative examples. So first let's talk about sovereign example. Okay? So when a minority, whether it be a state, an ethnic group, whatever, however we define the minority, when a minority in a lot of other federal systems is speaking and is kind of acting in their own autonomously, often they are required to consult with, in actually a very practical, tangible sense, with the majority. In the federalism context, it can be minority, it could be, the Länder in Germany and the central government, but there's a requirement, even when one is acting as a sovereign, that they do so interactively. Right? Same is true of kind of the servant modality. Right? So in some jurisdictions, and I would say in fact most jurisdictions, even when the periphery is being supplanted via supremacy clause or something like that by the center, there's still some sort of requirement of interaction between the two. So let me give you some doctrinal examples of how this works. One is the principle of comity, which you see a lot in kind of comparative federalism, which is some sort of good faith effort required on the part of both the center and the periphery to interact with each other and balancing powers, right? So in other words, it's not categorical in the sense that you can regulate criminal or not. It's not kind of one-shot deal, somebody regulates it, somebody else is supplanted, somebody regulates it or they're not supplanted at all. There's this kind of requirement of ongoing interaction. And in some kind of Spanish-influenced constitutional systems, Latin America, Spain, there's almost kind of phrased like a procedural due process, right? States have something, Ernie's written about kind of, states as autonomous actors, but the states have kind of procedural due process rights to be heard within the actual federal apparatus of the federal government. Now, this coexists with dual federalism, right? I mean, somebody is still acting as the final word, somebody is still acting as the servant, still are talking to each other a few days a week. And again, maybe they don't need to listen, maybe there's no kind of coercion in them to actually act in a particular way, but there's some sort of right to be heard. Another example, kind of more from the servant angle, is something that's now more common in domestic constitutional law. It starts off really as an EU concept, is the principle of subsidiarity, right? That if the central government really wants to do something, it has to document that it has a good reason for doing so. And usually that documentation will be based on some sort of evidence gathering about peripheral failures. So in some domestic constitutional systems now, if the federal government wants to act, this is something like what exists in kind of French constitutional law now, if the central government wants to act, they have to work together and kind of prove, not necessarily malfeasance, but some sort of incapacity to act on the periphery. So in both of these versions of kind of sovereign and servant, right, we have the sovereign acting as the final word, the central government making the final decision, or the state government making their final decision. But there's still a form of dialogue because of either mandatory or norms-based interaction. It would be very hard in Germany for the federal government to come in and completely preempt what the state government was doing without making some attempt to listen to the state government. So what's so interesting, there's a doctrinal categorical federalism, but and there's a lot of political science literature about this, what's just as interesting to me is how kind of phone call categorical federalism, right? In our system, the federal and the state have no legal obligation and very little practical interaction. The people in Washington don't talk to the people in Tallahassee or Albany as much as they do in other systems, partly because there's no constitutional apparatus for requiring this. Cooperative federalism is a little bit harder, right? I mean, cooperative federalism seems to have built in this idea of dialogue and interaction, but of course, cooperative federalism, at least as described in the American literature, still has kind of a clear principal and agent, and it's kind of harder to have dialogue when you have clear hierarchies. Again, in other systems, even when there's cooperative federalism, like in the German system, right? Even when the central government can, depending on if you believe Dan Halberstam or Justice Breyer, if the central government can commandeer states to do things, they still have to kind of work with them, and states do have kind of more of an opportunity to be heard and even potentially to resist within the system. So then I think part of what dissenting by deciding and second-order diversity is responding to is this particular form of federalism, right? Federalism is a kind of isolationism, one-shot deals. And so part of what my kind of practical reading of these articles, how would things be different the next day, is it would actually create more dialogue, practically speaking, between majority and minority, however we're deciding it, right? And you can see this in the articles, right? It has an agenda-shaping role. There's kind of a first-mover power, right? There's kind of the power you get from building experience and showing gay marriage isn't so bad, or regulating to prevent global warming isn't so bad. Those are all things that are kind of tools or outcomes that seem to be meant to induce somebody in the center paying attention to somebody in the periphery in the way in these other systems they would not have to. So let me kind of note some potential kind of more organizational structure critiques of this. So there's a real relationship between dialogue and creativity in political and other organizational psychology literature that's not quite an inverse relationship, something more of a bimodal relationship, actually. And it kind of stems from parts of psychology like construal theory. You see it in stuff about corporate structure, just things trying to understand how people in organizations interact with one another. We're much more creative. There's more laboratories. There's more experiments if the people that we're interacting with, we're not interacting with often or closely, right? So if you think about this, is what people will call, social psychologists in particular, kind of the difference between high-level and low-level construal. If there's somebody that you see a lot, you tend to project your own personal characteristics and views on them. You don't listen as much to them because you know what they're going to say, right? I mean, you don't need to listen for some new idea because you know all their familiar moves. Think of the opposite, right? Somebody who's distant. You listen to them more. You're more likely to hear something new, something different, and to perceive it differently. So a lot of organizations structure themselves in a way to kind of moderate this low level and high level, this close and distant relationship. Obviously, you don't want all distant. You don't want all close. The question is, what's the optimal kind of level of dialogue? So you'll see, for instance, like corporations, some of them decide daily meetings are too much. Yearly meetings are not enough. Monthly meetings are the right amount for creativity. This is something that you saw like in Bell Laboratories, great book on Bell Laboratories in the past year. Artists, some research on, there's an economist at Chicago who's written something about artistic creativity and found that, if painters meet every day, it's bad for them. If they never know of each other and they never talk, that's bad for them too. So the kind of Goldilocks of dialogue is what they're searching for. And this is, I think, also one of the great, this is a whole tangent, but one of the great arguments for looking to constitutional systems around the world is because people perceive them differently because they are so foreign. The way they look at them is different than the way they look at an American state. So part of the question then is, by creating dissenting by deciding, Professor Charles and others have talked about what that means in terms of who's deciding. Are they really deciding? Are they in dissent? Are they really kind of the state? What I'm more interested in is how much actual interaction will that create between Gavin Newsom and the governor of California, right? This is the anecdote that appears in a lot of the articles, appears in a lot of the presentations today. So let's think of three different, situations. The old situation, right? This is a bad example for this, but a dissenter does something, and because they're not deciding, or now maybe they are deciding, nobody even knows they did it, right? In that situation, there's no dialogue at all. There's no potential for learning. So the idea about having dissenters decide is to make somebody pay attention. So that gets us to like our second potential, Gavin Newsom situation, right? Maybe Gavin Newsom, has a press conference and justifies why he thinks the California Constitution compels him to issue certificates to same-sex couples trying to get married, right? The governor of California kind of looks at it, thinks about it a little bit. Still, there's kind of a dialogue, but there's still something of a social distance. Then imagine something else, like I'm describing a lot of this comparative federalism. Imagine that the governor then meets with Gavin Newsom once a week or every few days, right? This will, it might produce other good things. I'm not saying this is kind of all or nothing or this makes it bad, but in terms of kind of creating new ways of looking at government, it will potentially stifle experimentation if they're meeting every week in the same way it would stifle innovation if they never met at all. So kind of my response to the laboratory, a few responses to the laboratories theory. David Schleicher was saying earlier, there's not incentive, right? But my point would be, in some situations, in some federal systems, even with a desire, a motivation to do so, the way that people in the center and the periphery interact will prevent them from even being able to innovate if they had the incentive to do so, right? There will be particular relationships between the center and the periphery that might create more cooperation, might create less cooperation, but are creating kind of less innovation. So I'm skeptical slightly for different reasons than Professor Schleicher about the kind of laboratory's benefits of this. I think it could create more because, again, in my three Gavin Newsom situations, right, in order to learn from what a state is doing, you have to know that they're doing it in the first place. But if you know a little too much about how they're doing it, that can be potentially a problem too. So I don't have an answer for what the optimal amount of dialogue is, but the optimal amount of dialogue is somewhere between constant dissenting by deciding and constant conversation between majorities and minorities, and complete lack of conversation between majorities and minorities in the first place. So I think part of what you see among different federal systems is you actually the kind of comparative analog to Susan Rose Ackerman is that you see very different amounts of policy diffusion in different federal systems, and a lot of it depends on the interaction between the different parts of the federal system. So you could have our constitutional doctrine, but have slight modifications to it, and you could get a lot of the potential benefits that you get from dissenting by deciding. Let's say before you wanted to preempt a state government, you had a constitutional obligation to meet with them, justify it to them, and this was reviewable. It sounds absolutely insane to the American constitutional era, but this is the plurality way of preemption in most constitutional systems. In that sort of situation, the pressing need for dissenting by deciding is much less so, right? So I guess part of what I want to problematize in this framework, interaction between center and periphery, is even if we know who's deciding and who's not deciding, who's majority and who's minority, we still need to know their actual interactions to get a sense of what sorts of public goods it's actually going to be produced. Incentives or no incentives to actually innovate, the actual amount of innovation that will be produced will, in large part, or at least substantial part, be based on the actual interactions between the center and the periphery.